This podcast is published solely based off the interests of Jacko Law Group, PC, and in no way be construed as legal advice. The opinions shared reflect those of the authors and not necessarily the views of Jacko Law Group, PC. For more specific information or recent industry developments or situations, you should seek legal opinion or counsel. You are hereby notified that any review, dissemination, or copying of this message and its attachments, if any, is strictly prohibited. These materials may be considered attorney advertising in some jurisdictions.
Today, I'll be sharing some essentials of a purchase and sales agreement. For those involved in their first merger and acquisition, it can be overwhelming, especially during the process of creating a purchase and sales agreement. Luckily for you, our qualified team of merger and acquisition attorneys at Jacko Law Group are experienced in the many nuances that must be covered in purchase and sales agreements to consummate a successful business transaction. First, your contract has to have a detailed description of the transaction. It may seem simple, but your description needs to include who the parties are, what's being sold, closing date, purchase price, and any contingencies. It is also important to include what is and is not included in a transaction and any special conditions. Next, financing conditions are an essential component for the agreement. For example, will there be a promissory note and/or a guarantee agreement? What about a bill of sale or tax allocation agreement? Frequently, business transactions also have restricted covenants, which should be carefully reviewed by experienced counsel. Representations and warranties are also important because they include disclosures about the business to guarantee such factual aspects as a seller's ability to make the sale, the condition of the business, and the accuracy of financial statements. Many of these items tend to be heavily negotiated, and having experienced M&A legal counsel to assist is essential. The seller, for example, must be certain not to overpromise or underdeliver and risk the possibility of costly litigation. Furthermore, indemnity clauses often are included in the purchase and sale agreement as a means of allocating risk. Common risks include operational risk, financial risk, and regulatory risk. Likewise, a covenant is an enforceable promise by a buyer and a seller regarding actions they will or will not make between the signing of the purchase and sale agreement and the closing of the transaction. Common restrictive covenants can include a non-compete and a non-solicitation agreement. It's also important to include closing conditions. These conditions are agreed upon provisions that both parties must meet to close a transaction. Lastly, termination rights must be provided. This language provides the ability for any transaction under specified circumstances to be terminated before closing by mutual consent. Termination rights benefit both parties from unforeseen events, such as a global pandemic. The terms of any purchase and sales agreement are among the most important aspects of any merger and acquisition transaction, so it's important to have strong legal support during this process. Jacko Law Group can help. To find out more and to speak with our team, we invite you to contact us at 619-298-2880 or visit us online at jackolg.com. Thank you and have a wonderful day. Discussed in today's episode. To find out more and to speak with our team, we invite you to contact us at 619-298-2880 or visit us online at jackolg.com. Thanks for listening. We hope you have a great day.